Yes.
Milords convicted under section 376(2) and Milords for 15 years rigorous imprisonment. POXO Act, Milord, I have not been charged with. For the reason, Milord?
The reason is known.
Though that is there.
The offences carry
Yes.
similar punishment, therefore no separate sentence.
Right. Now, my lords, out of 12 charge sheet witnesses, I just cut it short because my lord has already heard it on merit. But for my satisfaction, my lord will hear it, my lord. 12 charge sheet witnesses, only 7 witnesses were examined. 5 witnesses could not be examined or were not examined. The parents of the victim girl, they have not been examined. They have not participated anywhere. Now, my lords, there are altogether 4 witnesses, including the victim, who is before my lord can be said to be the material witnesses. The one is, my lord, the chacha of the girl. The another is chachi of the girl. One is dadi of the girl, and fourth is the victim herself. Now, my lord, by off late the compromise had taken place. The girl had filed an application for, my lord, under section 313, my lord. Somehow, my lord, what happened to that, my lord, I have not been able to understand, my lord, so therefore I'll be fair enough to submit this. But the application is there and it could have been recalled at any stage, my lord. That did not happen. They have compromised, it is an admitted position. The girl who has married, she is having the privilege of marriage right now and the children. What she says is, my lord, that she had an affair with the appellant. False promise, my lord, I'll not say, I will say it can be said to be a breach of promise, my lord. At the best, if I look into the totality of the aspect of these 4 witnesses, including the victim. Victim says, my lord, that she was aware of, she was having affair, and thereafter they had the relationship. And one thing what is very common among all the 4 my lords, the witnesses, deposition, they have come up very proudly saying that she was having the relationship and the boy wanted to marry. Milords, this cannot go side by side to my understanding in our society in any aspect of the matter, even though the boy had promised or the boy had the intention of marrying. This may not go, Milord, to what I have understood by my age or my the situations which we are standing here. If my lord will look into all the witnesses, my lord, they say that they were having the relationship, we were aware of, the parents came, they settled the marriage, and this is the case, my lord.
Ms. Nirvikar, this argument may be attractive in the first blush, but it is in teeth of the judgment of Supreme Court in independent thoughts. Now, even if no case would have been filed, you would have been an accused of POXO. The girl was a minor that time.
Now,
so there is no consent whatsoever.
Now, I'll clarify that, my lords. The medical examination was held, my lord.
And on top of it,
my lord,
you are related.
I am not related. I'll come to that. My lord, so far as the POXO Act is concerned, my lord, that will give me a liberty
We'll tell you one thing, just to cut short the matter. You can have your complete argument. You can have your say. We are not cutting short.
My lord.
But see, here the number of witnesses would not be important.
Lord.
We can be satisfied with the statement of the victim girl if that statement inspires confidence. Now, as you say, the victim is now married and has children. That is one of the mitigating features for us to consider, but not now. Number one, that you have committed a felony which is beyond the stage of being forgiven. And number two, when you make the statement that the parties had decided and had at one point of time thought of compounding the offence, it goes against you again. So therefore
I was trying to, my lord, I was trying to
we quite see
submit,
the only mitigating feature here is this, that you know the law today as it stands.
My lord, I am conscious of the
For
fact.
every sexual encounter there has to be a consent. Now this lady was not competent to give consent.
Now, my lord, let me, my lords, this is what I am submitting. My lord, a medical board was constituted.
No,
And
that
the
is,
medical board, my lord,
that is no evidence.
my lord, the medical board says, my lord, that she should be in between 15 to 17 years. Now, my lord, if my lord will kindly see, my lord, 375, I'll just drop, I will cut short my argument, my lord. I will not go into a deep root of the entire issues. I am not going to read the entire evidences which is there, only the relevant part. My lord, so far as 375 and section 90, I will go side by side, my lord. First, I will draw his lordship's attention to 375, my lord, where there are 6 conditions which has been, my lord, in fact mentioned, whereby 375 would be applicable. And the last, ये 6 में से कोई मेरे ऊपर अप्लाई नहीं करता है, I can demonstrate, my lord. But cutting short the entire issue, if I go to the 6th issue, my lord, straight away, with or without her consent when she is under 16 years of age. My lord, the medical board constituted, my lord, would give me a benefit of doubt. I have been said to be, my lord, in between 15 to 17 years.
But this came, they can at least.
Section 90 जो है of the IPC says that the consent is taken on misrepresentation, misconception of fact. 2019 CC में Supreme Court बोल किया कि बहुत से marriage से आप sexual relation कराते हैं.
My lord, so this itself, if may I, my lord?
Yes.
This section 375, my lord, the sixthly with or without her consent when she is under 16, my lord. Admittedly, my lords, the doctors have opined that she is in between 15 to 17 years.
What is the date of occurrence?
My lord, so the date of occurrence is, my lord, 7/5/15, my lord.
And you know that this 16 was extended to 18 much before in 2013 only. Section 375 was amended in 2013 only.
Now
And
when
the
my
age of
lord,
16 was increased to age of 18.
You are placing from the old book, madam.
maybe, my lord. नहीं, लेकिन ये तो नया ही वाला किताब है, नया ही किताब है। नहीं, कुछ amendment तो आया था, and my
नहीं,
lord
नहीं,
is very
amendment
correct.
है,
This is 2008.
अठारह-
Let me presume for a minute, my lord. Let me.
This argument then goes.
My
You
lord.
don't proceed with
Then
that
very
argument.
well, my lord. I am closing that argument of mine. But, my lord, at the same time, section 90 is also applicable. That more so, my lord. I am not going into any sections, my lord, anything. If I just go on the witnesses who have been examined, the mother, father has not come up, my lord. It is only the victim who is saying. And the victim, what does she say? That on the very second occasion, the first occasion she meets in a neighbor's house my lord, where the appellant was there. In the neighbor's house, for the first time she meets, and for the first time, my lord, when they go together all alone, my lord, she says to have established the relationship. So, my lord, what I am saying, that it is specifically in her, my lord, statement that she developed the love affair with the boy. It is there in the statement that they developed through telephone and on the very first occasion. So, my lord, there cannot be a promise made and thereafter, my lords, to have been established any kind of further relationship, my lord. So, it was out of her own willingness, my lord, she proceeded.
That argument is foreclosed.
My lord,
Now, assuming for the sake of argument that they had some relationship,
my lord,
but because of her age being less than 18, conclusively,
my lord.
everything goes in background. It vanishes in thin air.
My lord, I am keeping it, my lord, I haven't, my lord, understood, my lord, what is falling from my lord, my lord. Now for 1 minute, my lord, if my lord will just go through the depositions, my lord, slightly even, I would not request my lord to go into the entire evidences because long evidences have been, my lord, there and the depositions. What I was submitting, can there be a situation, my lord, I am just trying to defend myself here, my lord. Can there be a situation, my lord, that there is a boy who is related to the neighbor's house relationship? He comes to my house very often, and it is in the knowledge of the uncle, auntie, mother, father, grandmother, that too in a village, Not even in a शहर where people are not unknown of or the has the knowledge of.
देखिए ये सब बहस इसलिए नहीं important है.
जी.
I mean, I would just like to remind you
Not-
that we are not guided by social norms and mores.
Very well,
We are
my lord.
guided by the strict letters of law. Now, in tribal system, there are many things which does not have the sanction of law.
My
Do
lord.
we say that it is the practice and therefore we should presume? Now, the parents of the girl and the parents of the boy were in know of the relationship between the boy and the girl.
My lords.
Now, but what we are concerned with is whether the offence has been made out, whether there is evidence. Now,
Milords,
the only
the-
mitigating
my
feature
lord,
in
my
your
lord,
case is,
my lord,
kindly
in
hear
the
what we are considering in your favor,
My lord.
is that the victim is now happily married
My lords.
with children and you are in custody.
My lord.
So therefore, this
That
is
to almost 4 years I am in
that's
custody.
right, but we are not getting persuaded to suspend your sentence on this ground for the time being.
My lords, I may be granted bail. Let this matter come up for hearing, my lord. I have no issues to that, my lord. If he would have to face the sentence, he would face the sentence, my lord. Right now, my lord, I am before my lord only with respect to that, my lord. And my lords,
Since when you are in custody?
my lords, I am in custody. First, my lord, initially I was there for 8 months, and then again from 22/1/2019. Before conviction, I was there for 8 months, my lord. It has been wrongly mentioned in the order sheet 1.5 years, my lord. It is 8 months.
We are not persuaded.
My lords,
Now
there is-
we can give you an option.
my lord.
We are rejecting this interlocutory application for the present. If at all you would insist for any observation, when would you come back to us again? We give you 2 years. If you don't want that observation, we leave it open-ended.
My lords, हमारे पास तो कोई ऑप्शन नहीं है except this, my lord, that
नहीं, ऐसा नहीं
whatever
है।
comes from my lord,
ऐसा
my lord,
नहीं,
I have to
ऐसा नहीं है।
accept it.
Look at this.
But what I would
Madam
request, my
Counsel,
lord.
you first, I mean, one thing at a time. When you say that you don't have a choice, you are alluding to the Hobson's choice, that accept whatever the court
I
gives
have
you.
to accept, my lord. This is what I am
So
saying.
therefore, do you know what was the background behind coining this word Hobson's choice? Hobson's choice is that you have practically no choice. Whatever the
I
court is
understand.
giving you. So why this Hobson's choice? Would you be interested in knowing what is this expression? What does this expression means?
Surely, my lord.
Therefore, I'll tell you what it is, because it's always very interesting to know about the etymology.
My lords.
What is the reason? Now, in 17th, 18th century,
My lord.
when there was a system of carriage continuing in England, one Mr. Thomas Hobson used to provide horses to anybody who wanted horses. And he had the best quality of horses, and all viscounts and generals and big, landed gentry, those who used to have their own carriages, they purchased horses from Hobson. Hobson used to give horses, but he had a condition. The condition was that any purchaser cannot have a choice. The horse which is standing nearest to the gate of the stable, the first horse near the gate, that only shall be given, no matter whatever is the price charged for. So therefore, it was practically no choice except the horse who was standing there at the stable. And therefore, later, in
At
many
the,
many of the
at the moment, my lord, since I have already been given a choice, but I would just like
here
to,
we have given you two choices.
let's, I
So therefore
wanted to,
it is not a options choice. Either you have an order of rejection with an open-ended kind of wording, so that you can come anytime that you feel like. Or if you want an observation, we'll give it for 2 years.
what I was submitting, my lords, that is already there when it has come from my lord. What I was just trying to submit, my lord, that in these similar circumstances, my lord, we have nothing except the statement of the victim.
Look here,
My lord,
I'll tell you what.
my
Well,
lord,
let me add something to what you have argued.
my lords,
We would have agreed to your submissions,
my lord,
taking into account the judgment rendered in Dilip Singh's case.
my lords, and
Not
also
with,
my
not
lords,
with,
Deepak Gulati's
not,
case, my lord.
notwithstanding all other law independent thoughts and everything, but for the fact that the victim was a minor that time. This takes away everything from your kitty.
I would just like to, my lord, since I was not forwarding this, because my lord, there is one decision in the similar, exactly similar circumstances. I am finding it that it is my case, but my lord, I just have one copy of it, so that was the difficulty, because the another,
Name the case.
it is my lord, Sonu alias Subhas Kumar versus State of Uttar Pradesh and another. My lord, this is an SLP, my lord. They had gone for the washing.
My Lord Justice Sinha has 10 such cases in similar circumstances where bail has been refused even when he has remained in custody for 7 years.
Yes, my lord had the occasions of going through so many issues, my lord, but it is for me one case where I would like to request my lord to consider.
We leave it open-ended. Here.
नहीं तो ठीक है, हम आते हैं, अब 2 साल थोड़ा सा ज्यादा है,
मैं तो
because
आपको ऑप्शन दिया, चॉइस दिया, आप
my
उसको
lord,
ऑप्शन चॉइस
my request would be, my lord, that since I am already in custody for 3 years, almost 9 months, 3 years.
Today we have granted, we have suspended sentence in every case whatsoever where a person is in custody beyond 7 years.
So that to be a little lesser, my lord, my only request.
Open-ended. Open-ended. Look here. Heard MS Nivita Nirvikar, learned senior advocate for the appellant applicant, and Mr. Manu Sharma for the estate. The appellant applicant has renewed his prayer for bail and suspension of sentence on the ground that the victim is now happily married somewhere else with children, whereas the appellant applicant has been in jail for about 4 years. She has further argued that from the evidence on record it would appear that not only the victim girl, it would appear that the parents of the appellant applicant and the victim were aware of the relationship which had flourished between the victim and the appellant applicant, and therefore there is a possibility of false implication when the marriage could not be performed. MS Nirvikar has further argued that there could be myriad reasons why a promise be not fulfilled. Promise may not be fulfilled, but that ipso facto would not lead to the only inescapable conclusion that the victim was doled out a promise of marriage, and on the strength of such promise, she was subjected to sexual intercourse. As opposed to the aforesaid contention, Mr. Abhimanyu Sharma, learned counsel for the state, has opposed the grant of bail and suspension of sentence on the ground that the victim at the relevant time was a minor, and therefore all these grounds would vanish in thin air. Neither the victim nor anybody on her behalf could have given consent for her to be sexually exploited for whatever reason whatsoever. After having heard the counsel for the parties, we are not persuaded to revisit the order rejecting the prayer for bail and suspension of sentence of the appellant during the period during the pendency of this appeal. The IA petition therefore is rejected.
That's
We are left it open.
liberty, my lord.
Liberty, then 2 years.
थोड़ा
Come back
सा,
to us again.
my
Let us see.
request was only, my lord,
You will have
thoda sa
some other,
consideration
you will have
to
some
the,
other judgments
she
later
has,
down the line.
he has already remained in custody